Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Welcome to another episode of Empowering Plans. I'm your host, Kelly Dempsey, along with Naga, Vivekanandan, and we are going over wellness programs. It's been a long time since we've talked about this, but there's been a recent increase in litigation related specifically to tobacco surcharges in certain wellness programs. And this is particularly relevant for ERISA self-funded plans with the way that wellness programs are set up, especially because there is direct employer liability associated with wellness programs when they go awry. And there's also the enforcement through ERISA litigation as opposed to state insurance regulations. So we're excited to talk about these cases because it's been a while. And unfortunately, we're going to give you a quick background of really what hasn't changed at this point, because there's been some regulatory limbo related to wellness programs for quite a long time. And quite a long time, I truly mean all the way back to 2019. There was a lot of litigation related to what makes a wellness program voluntary. So with that, we'll dive in and we'll talk about a little bit about the background of wellness programs to kind of just lay the foundation. And then we'll dive into a couple of the recent lawsuits that are happening and why they are piquing our interest right now. So wellness programs are generally obviously associated with self-funded plans for a few specific reasons: cost containment, first and foremost, risk management, and then behavior modification. Obviously, when participants on a health plan are healthier, they generally incur less claims, which reduces claims cost. So a wellness program is generally designed to work towards that goal of making all the plan participants a little bit more healthy and reduce the claims cost. So there are a couple different types of wellness programs, and this is a very large web that we weave when it comes to wellness programs. We could really actually talk about wellness programs for hours. It's really hard to cover all the nuances of wellness programs in 10 or 15 minutes, especially, let alone a couple of hours. So we're going to do this very high level, but obviously if you have questions, you know how to get a hold of us. So with the wellness programs, there are participatory wellness programs, and then there are health contingent wellness programs. So participatory are generally education only. It truly just means you're giving individuals pretty much information. And then when it comes to health contingent, there are two types. There are activity only and there are outcome-based wellness programs. So the activity only is truly just they're participating and there's not a specific goal that they have to meet. Whereas an outcome-based, we're trying to meet a very specific goal and target. There are definitely also additional nuances related to those health contingent wellness programs that we'll dive a little bit further into as we go through this podcast. But again, self-funded plans rely heavily on wellness programs to help that claims volatility, and especially because this is the employer funding the health plan. So there's more risk to the employer when the employees are not healthy and potentially incurring larger claims. So like I said, when we talked about the threshold for wellness programs and what is and is not voluntary, that's kind of what's been in limbo. Generally, a wellness program cannot exceed the penalty, or the reward cannot exceed 30% of the total cost of coverage. Now, again, there's some nuances with that, and it also depends on which laws you are triggering. And we'll talk about that also a little bit later. But before we dive any further into that topic, I'm going to let Naga talk a little bit about tobacco surcharges and how they change that threshold for 30%. So Naga, why don't you tell us about tobacco surcharges and what they are and what they mean?
Sure. So first, I want to make sure that we're all talking about the same thing when we say tobacco surcharge, because this is where a lot of confusion starts. At its simplest level, a tobacco surcharge is an additional premium contribution that is imposed on plan participants who are using tobacco. And in real life, that just means higher payroll deductions. Employees either see a flat dollar increase per paycheck or a percentage increase in what they contribute toward coverage. So what makes tobacco surcharges legally different from other premium structures is why they are imposed. Tobacco use is treated as a health factor under federal law. So these surcharges aren't just pricing decisions. They are regulated as health contingent wellness incentives. And that distinction matters a lot for self-funded plans. These surcharges are paid with employee contributions, but they are governed by ERISA plan rules and not state insurance law. There's no carrier that's absorbing risk here. The employer is designing the program, administering it, and defending it if something goes wrong. There's also a special rule that applies only to tobacco. So most wellness programs are capped at 30% of the cost of coverage because that's where ADA and GINA concerns come in, along with the ACA concerns, because regulators generally assume people will fail health-related programs. Tobacco is treated differently. Tobacco incentives can go up to 50% of the cost of coverage, and the reason is historical and practical. Tobacco use has long been associated with higher claims costs, more comorbidities, and greater long-term risk. So regulators wanted to give plans more leverage to address that. But for tobacco programs, the law assumes that employees can succeed. You don't actually have to quit smoking. You just have to complete the alternative, which is usually just a cessation program. And that is why courts keep emphasizing that the surcharge has to function as a reversible incentive and not a fixed penalty. If employees can't realistically avoid it, the entire structure starts to fall apart. And that's where the rules around how these programs operate really start to matter, which brings us back to Kelly to walk through the governing rules.
So I'm going to throw a wrench in that because I want to clarify one thing. But when you talk about tobacco surcharge, what tobacco products are we talking about? Is there any sort of limitation, or is it just truly anything that has tobacco?
It's truly anything that has tobacco. I'm glad you brought that up. It could be cigarettes, cigars, dip products, chewing tobacco, really anything that has tobacco.
All right, that's good to know. And when you say tobacco cessation and that there's that alternative, it doesn't mean they actually have to quit smoking, right?
Yes, you just have to complete the alternative. So you just have to complete the program.
I think that's something that has hung up some of our clients in the past about the fact that when it comes to a cessation program, the goal doesn't actually have to, the end result, not the goal. The goal is obviously to get them to quit, but the end result doesn't actually have to be them stopping using tobacco at the end of the day, which I feel like is potentially a point of confusion for a lot of people.
Definitely.
All right. So when we talk about the governing laws, Naga gave a couple of laws that she mentioned specifically, but it really is alphabet soup as to what laws are triggered based on the structure of the program. So based on how you structure your program and what you're doing and whether or not you are taking any sort of bodily fluid samples like a blood draw or a saliva swab, that will help you determine what laws you trigger. So you can truly trigger a handful of federal laws: ERISA, HIPAA, the ACA, the ADA, and GINA. So it's all of them. And it really just depends on how you set up the program, which is why we could spend hours talking about this topic. So it's important for employers to know when they set up their program to truly figure out, with an expert, what laws they're actually triggering so they can be sure that they can comply, because the thresholds, like Naga kind of hinted at, the thresholds for completion of the program and the incentives that goes along with the program may change based on which laws you trigger, especially if you have a tobacco surcharge as well. So it's very interesting and very challenging, and that's why at its core, wellness programs seem very simple. But at the end of the day, they're actually way more complicated than a lot of people realize. So the core requirements for an outcome-based wellness program, I think, are an important thing to go over in this situation. And it's specifically because of these tobacco cessation, they generally fall in that outcome-based wellness program. So you have to have an annual opportunity to qualify for the reward. The reward has to be available to all similarly situated individuals. There has to be a reasonable alternative standard, which Naga will talk about a little bit more detail next. And the full reward must be available once the requirements are met. So the full reward, even if it takes them 6-8 months to complete whatever the process is, they still need to have the full reward. And that's going to be a key issue that you're going to hear about a little bit more as we go through this. But Naga, why don't you tell me a little bit about reasonable alternative standard and what that means?
Sure. So these are pretty important because if there is one place where these programs break down, this is it. The whole purpose of a reasonable alternative standard is to make sure that participants aren't locked out of affordable coverage because of a health factor. So for tobacco surcharges, the alternative is what gives the program its legitimacy. And in most plans, that alternative is some form of tobacco cessation program, as we were talking about earlier. It could be counseling, it could be an educational course, or it could be a physician recommended alternative if quitting immediately isn't medically appropriate. Again, you don't actually have to quit. You just have to you would just have to go through this program and complete the program. But courts are not asking whether an alternative exists somewhere. They're asking whether it actually works in practice. So that means the alternative has to be easy to access. It can't impose unreasonable costs or time burdens on anyone. Employees have to know that the alternative exists. They have to understand how to enroll in it, and they have to be able to complete it early enough in the plan year for it to matter financially. So one thing that is very common, timing is a huge issue. If an employee doesn't learn about the alternative until months into the year, the surcharge has already hit their paycheck multiple times. So even if they comply, prospective only relief can mean that they have paid hundreds or thousands more than they actually should have. Courts are also very focused on flexibility. So if a program demands immediate cessation of tobacco use with no accommodation for medical advice, that raises red flags. A rigid program looks less like a wellness incentive and more like a punishment. So what we see again and again in litigation is that the reasonable alternative exists on paper, but not in reality. And from a court's perspective, a theoretical alternative is not enough. And then once you kind of combine that with the legal requirements, it really explains why these cases are getting so much traction, which brings us into the litigation, which Kelly will talk about.
Yeah, thanks, Naga. I think it's really important that sometimes when we talk about, are you going to use a carrot or a stick? It's important with wellness programs to go with the carrot approach, even though sometimes they can seem very similar, but they are very different as how the rollout is, at least from the perception of individuals. And in this case, the individuals are plan participants, which are the ones that the courts are generally more deferential to when it comes to wellness programs, which is why when we see wellness program litigation, they generally the courts allow these cases to proceed because they want to be deferential to those plan participants. So we have two cases that we're going to talk about: Williams versus Bally Management Group and Knight versus LHC Group. And the facts of these cases are relatively similar, and we'll go through each of them. The big difference and where they differentiate is that one was allowed to proceed in court, whereas one was dismissed. Because naturally, with the litigation and the way these things play out, is the employers typically try to file a motion to dismiss to get the case dismissed for whatever reason of why they're fighting back on the case. So one was allowed to proceed and one was dismissed. So first we'll talk about the Williams case. And the question here was whether the employer, Bally's, was self-funded health plan. They had a tobacco surcharge, and whether or not they violated the wellness program rules by failing to provide a meaningful way for employees to avoid the surcharge and get the full incentive. So in this case, they had a self-funded health plan with the wellness program with the tobacco cessation piece of it. So they had a tobacco surcharge, and employees were required to pay a higher premium unless they met certain tobacco-related requirements. So in this case, they had a tobacco cessation option, but the employees alleged that they did not know how to use the cessation program to avoid the surcharge. The surcharge was automatically applied through payroll deductions, and that completing the cessation program only removed the surcharge on a prospective basis and not for amounts already paid. You might remember a couple minutes ago, we talked about the fact that the full reward needs to be available to plan participants in order to satisfy the requirements of the wellness program. So the employees claimed that they continued to pay higher premiums even after they had attempted to comply, and that the surcharges function more like that penalty, that stick, than an actual incentive. So in this situation, the outcome was that the case was allowed to proceed. The employer, Bally's, did file a motion to dismiss, and the court said, no, we're gonna go forward. So this case is actually still being litigated. It's not done yet. So at this point, again, the employer was unfortunately unable to defeat the claim that the plaintiffs had a case here. So it is moving forward. So that's, again, a hard lesson for Bally's in that situation. But obviously, we'll see how the final case plays out. We're going to try to follow this one through to the end. Unfortunately, sometimes these cases obviously take quite a while to work through the court system. So no idea when we're actually going to get the final outcome, or if, there's always the opportunity for a settlement as well, that generally gives a little less clarity. But we'll follow this case to the end and see what happens on the other side. Then we have the Knight case. And in Knight, there was also a tobacco surcharge associated with the wellness program. So again, we're triggering the same kind of rules and issues that happened in the Williams case. And in this case, they also had a self-funded health plan too. Employees were charged the higher premium unless they satisfied the requirements. But in this case, LHC, as the employer, provided significant detailed materials that they handed out to their plan participants, explaining about the tobacco cessation program alternative and the steps required to avoid and remove that surcharge. The plaintiffs still argued in this case that the surcharge was applied by default and that relief may not have been fully applied retroactively once they met the threshold for that program completion. However, the documentation that was provided was pretty good. The LHC did a great job with their documentation and explaining the surcharge and how to get the surcharge removed. So the court was a little bit more open to hearing the responses from the employer in this case, and they did dismiss this case. So it is not moving forward. The claims were narrow and were treated, more favorably compared to Bally's due to those disclosures. So that's the important piece. They documented. They had all the information and they made it simple and easy for their plan participants to understand. And I know that sometimes, as lawyers, Naga and I hear that, you're so hung up on these documentations and looking at things on a case-by-case basis. Well, unfortunately, I feel like that's the first thing they teach you in law school, is that everything it depends. It's a case-by-case basis, and document. Those are what we're taught. So again, those are the facts of the case that we'll lay out, but Naga will dive in a little bit more into what went wrong, specifically for the Williams versus Bally case, and what was the issue and what they could have done differently.
So the most important thing to say up front is this, and that's that courts are not saying tobacco surcharges are illegal. That's not what Williams or Knight stands for. What courts are doing is scrutinizing how these programs operate in real life. So in Williams, the court was troubled by the allegations that the surcharge applied automatically, that employees did not clearly understand how to avoid the surcharge, and that even after attempting to comply, the relief only applied going forward. So from the court's perspective, that starts to look less like an incentive and more like a penalty. And that's why the case survived early dismissal. It moved on. Not because Bally definitively violated the law, but that's because the allegations, which were taken as true, suggested that the program might not have given employees a real chance to earn the full incentive. In Knight, the outcome was different. LHC, the employer, did not have a perfect program, but it had clear disclosures, it had more detailed wellness materials, and it had a more obvious link between completing the alternative and removing the surcharge. So even though plaintiffs still were raising concerns, especially around the retroactive relief, the court was more receptive to LHC's arguments. The claims were narrowed, and the employer was in a much stronger defensive position. So what separates these cases isn't legal theory, it's execution, communication, timing, and follow-through. Courts are asking very basic questions. Did the employees know how to avoid the surcharge? Could they realistically avoid the surcharge? And when they did they actually get the benefit? If any of those answers are unclear, the employer is then exposed. So taken together, these cases are sending a pretty consistent message. Courts are not anti-wellness, they aren't anti-tobacco incentives, but they are deeply skeptical of programs that look punitive in practice. Williams shows how poor communication and prospective-only relief can sink a program early, and Knight shows that clear disclosures and better administration don't eliminate risk, but they absolutely improve outcomes. So for self-funded plans, the lesson is that tobacco surcharges live or die on administration and not intent. As Kelly was saying, document, that's the most important thing. And I'll hand it back to Kelly to wrap this up and sort of talk about what employers should be thinking about next.
Yeah, I mean, I think, again, when it comes to these cases, we don't see a lot of wellness program cases get dismissed early. And I think that that's why these two really caught our eye, especially because the facts were so similar to a certain extent that it made it very interesting that one survived and one did not. And survived from, obviously, the plaintiff's perspective that it's still going in court. So again, we'll see what the outcome is. There's no, saying, obviously, Naga and I are making predictions that we think that in this case, unfortunately, Bally's looks like they're probably in a little bit of trouble. But we don't know. We're just guessing. We're using our crystal balls and our experience from looking at these cases in the past to see what might happen in the future. But, the important thing is, again, with wellness programs, and just to summarize it all, is that wellness programs are another one of those concepts that seem really simple at the onset. And the goal is very simpler. It's to make your plan participants healthier. And that's really why employers offer these is, first and foremost, for the plan participants' benefit. Secondly, because it helps reduce claim costs. Healthier people generally incur less claims. So, that is one of the main reasons. And we definitely encourage employers to offer the wellness programs. It's a great idea. It's a good thing to do. The thing that you have to pay attention to is the rules. And that's where the complexity sets in, and you will need to know which laws you're triggering so you can understand how to structure your program in a compliant way and keep yourself out of court. So if you have any questions, you know where to get a hold of us, because again, this is a very nuanced topic. But again, maybe we'll see. Maybe it'll be 6 months from now, maybe it'll be a year, but maybe Naga and I might revisit this on a future podcast. So thank you again for joining us today, and have a great day.